Well, good morning or good afternoon to everyone, depending on where you are. Thank you for coming to today's Secure Act presentation, and I want to thank everybody who's actually participating via webinar as well. I think we have over 300 people who signed up to view this via webinar, and that seems, given the current situation with the coronavirus, to be the way things are moving somewhat. But we also have a live audience here, and we're appreciative of that so that they can pose some questions to us as we go through things. My name is Tim Goodman. I'm a partner here at Dorsey and Whitney in the benefits and compensation area. I'm going to do some brief introductions here. Way to my far left is Bridget Logstrom Koci. She is a partner in the tax trust estates area here at Dorsey and Whitney. Next to her is my colleague Mike Voves, a partner in the benefits and compensation group, and Tim Arends, also a partner in the benefits and compensation group, and Holly Fistler, who's a senior attorney in our group. And we're here today to talk about the Secure Act. So please do a few real quick housekeeping things, and then we're going to go from there. Please do feel free, if you have any questions for the live audience, to ask questions as we're going. We're always happy to get those questions, and that helps us understand what people would like to talk more about, so we welcome those questions. In terms of the materials here, for the people who are on the webinar, a copy of the materials were included with the email that was sent out. If you do have any problems, you can email Dorsey back and check on those materials and other aspects. And with that, we won't do more, but we'll go ahead and just note our second slide here, and we'll try and announce which slide we're on as we're going for the folks on the webinar, really provides sort of an overview of the topics we're going to be covering. As you can see, it's a long laundry list of topics because the Secure Act has a long laundry list of things. In some ways, a lot of people have commented that the Secure Act maybe isn't as sweeping or as in-depth maybe as the Pension Protection Act back in 2006, but it does touch on a lot of different topics, and we're going to try and go over all of them so that you're familiar with them. With that, I'm actually going to turn it over to Bridget and Mike to start talking about changes that are effective with respect to the age distributions have to begin and the period of time over which distributions have to begin. Bridget?
Hi, thank you, everyone. I'm just going to be sitting in for a little bit. As Tim indicated, I'm in the tax group. I like to consider myself slightly different from the other panelists from the standpoint that I do disability, death, and taxes. So I'm known as the DDT of Dorsey. And for anyone who's too young, DDT was a terrible toxic thing back in the 50s and 60s, I believe. So with that as background, and again, I'm only going to take a few minutes, but the rules with respect to the income tax benefits of retirement plans and IRAs have changed significantly with the Secure Act. In the old days, what we would do is indicated on this slide, which I believe is page 3 of your outline, is we would try our best to have the beneficiary of the retirement plan or the IRA stretch it over their lifetime and receive then the minimum distributions on a fairly helpful tax basis, because only what you received in that year would in fact be subject to the income tax. In my world, we represent a lot of clients that have younger family members, and so we often talk to them about having trusts be the recipient of the plan benefits or the IRA, and use trusts to then hopefully stretch those distributions. And the most common type of trust was what we called a conduit trust. And that trust in the old days would allow us to look through the trust to who the beneficiary was and use that beneficiary's life expectancy in order to qualify for smaller distributions over the life of that person, and of course spread out the income tax consequences of the retirement assets. Well, unfortunately, the stretch feature has really been taken away as a result of the Secure Act. And as the next slide indicates, which is slide number 4 or page number 4, now in most cases, we are going to have to face up to the tax hit on retirement benefits within 10 years following the death of either the plan participant or the IRA owner. Now, fortunately, we have a few exceptions, and a surviving spouse is clearly one of them. But for estate planners, we are trying to encourage all of our clients, when it comes time to looking at their beneficiary designations, to please contact us, because the rules have significantly changed. Unfortunately, the conduit trust is not going to work like it did before. We are not going to get to use the life expectancy of the beneficiary and pull out small amounts in early years and spread out the income tax consequence. And why that's so important is a lot of people put trusts into their plans because, let's be honest, a lot of our family members aren't perfect. We have children or grandchildren who struggle with chemical abuse, maybe aren't wise money managers, may not be in the best of marriages. And so we may not want them to receive the retirement dollars or the IRA benefits within a 10-year time period. And why this is so important is, and then I'll jump ahead and let Mike take over, but trusts are hit up with the top tax bracket as soon as they have about $12,000 of taxable income. Whereas individuals, we can have hundreds of thousands of dollars before we are at the highest tax bracket. So now there is a real tension between income tax liability associated with retirement plans and IRA benefits, and possibly planning long-term to hold assets in trust for children, grandchildren, or others who may not be wise money managers or have other problems or concerns that distributing the assets to them might give you the best tax benefit, but not the best personal benefit. So we are asking all of our clients, and as you might get questions from some of your employees as to who they should name as a beneficiary, I think this is a good time to talk to your estate planning attorney because the rules have significantly changed.
Thank you, Bridget. So, Bridget was really talking from the perspective of an estate planner and thinking about these. I would like to stay on this topic for a little bit, and I might just go back to this slide just for a minute, and to talk about it a little bit from the employer plan sponsor's perspective. We expect many of you are in some way involved with designing, maintaining, administering qualified retirement plans. So how might these rules affect you? And the first thing I want to mention is that these rules specifically apply to participants in the case of a qualified plan who have not yet reached their required beginning date. So they die before their required beginning date. There are circumstances where a person may have actually reached their required beginning date and has started to take distributions over the participant's life expectancy. This isn't stretch, as Bridget was referring to, but it is possible in that case if the participant dies after their required beginning date for the beneficiary, including a non-natural beneficiary like a trust of some kind, to continue to receive payment over the participant's remaining life expectancy, or we might say in that case the decedent's remaining life expectancy. So I want to emphasize the new rules are really geared towards situations where the participant dies before the required beginning date, and what it eliminates is the ability to stretch that payment over the beneficiary's life expectancy, which was very, very common. And as Bridget pointed out, although there are some exceptions here, they're very limited. You will see here that minor children of the participant qualify still for the so-called stretch. But that's interesting because although most of these sort of criteria are determined at the time of the participant's death, this is one that actually has to be continually monitored. So if a participant dies and the beneficiary is a minor at that time, they can then eke out little minimum required distributions over their life expectancy. But once they reach the age of majority, at that point, they have 10 years from that point forward. So there's even little details there to look at in that regard.
Mike, can I just say, even with that, it's complicated because if the minor child who becomes majority, let's say it's age 18 in your state, goes off to college, there is some delay based on seeking additional education before the 10 years. So these rules are in very little guidance, and they're all in a state of flux as to, well, what is meant by education? Is it just college? Is it grad school? Any number of things.
Yeah, that's an excellent point. We would hope we will get additional guidance on, because as Bridget said, there's a provision in existing regulations that talks about for somebody who is say 18 and who has not completed, and I forget what the phrase is, how did you put it? Like has not completed some course of education or
Yes.
something like that, then that would delay their attainment of the age majority. So anyway, we'll stay tuned for that. Just also want to point out that, again, from an employer-sponsor plan perspective, these rules, these are sort of lay out the maximum time frame over which a person, has to start taking distributions. Not all plans contain that level of flexibility. In fact, many employer-sponsored plans have more rigid provisions that say once you reach a certain point, you have to take distribution. It might be in a lump sum. It might not be in required minimum amounts over your life expectancy. So it's important to keep that in mind as well, that the plan itself may be more restrictive than what the law requires, because sponsors are not required to offer these sort of flexible distribution features. And in that case, we would expect to see somebody to take a distribution perhaps in a lump sum and to roll it into an IRA and then piecemeal it out in accordance with these rules. So with that, we'll move on to a couple related topics, but yet different. Secure Act also removed the age limitation on contributions to traditional IRAs. Previously, they had been prohibited after a person attains age 70.5. That has now been taken away and removed, so that's a bit of good news. Keep in mind that if you are making a contribution for 2019, technically that's still governed by the old rules. So, you have up until April 15th of this year in order to make that contribution, but it is going to be limited to taxpayers who are under age 70.5. The new rule kicks in for years 2020 and beyond. And also, just in case you didn't know, Roth IRAs that were, just because of the fact that they're after tax, they were never subject to an age limitation in the first place. So traditional IRAs are now sort of on par with Roth IRAs in that you can make just contributions at any time, even after age 70.5. And then finally, the Secure Act also changed the required beginning date at which a person must start taking distributions out of qualified plans and IRAs. Previously, the rule had been you have to start no later than April 1st of the calendar year following your attainment of age 70.5. For a qualified plan, there's a little exception that if you're still working at that time, you can delay the distribution until you actually terminate employment. The rule now has changed the age marker from 70.5 to 72, and that applies to participants and IRA owners that anybody who turns 70.5 after December 31, 2019. So if you turn 70.5 this year or beyond, you're governed really by the age 72 rule. So unfortunately, if you'd already turned 70.5, you're kind of stuck with the old rules. There is, again, specific to plan sponsor considerations, and it's not like the same thing, but it is tied to an age 70.5 rule. And I think it's important for you to hear this. So for those of you that work for companies that still have pension plans, and I mean like the old-fashioned defined benefit style pension plan, you may know that for those employees that continue to work past 70.5, they're legally entitled to an actuarial increase adjustment to their pension benefit. That rule is still tied to age 70.5. That did not change to 72. So don't conflate the two things. Don't assume that wherever in the tax code it refers to 70.5, everything is now 72. That was very specific to required beginning date distributions. That has nothing to do with the rules around having to make mandated actuarial adjustments to pension plans. So with that, I think that covers the changes around required beginning dates and required beginning distributions and contributions. And we'll put a plug in again for Bridget to say that you should consult your estate planning attorney These are major changes, significant changes, as Bridget alluded to, that there's this complicated tension of, is there really a reason to still do a conduit trust when there's a high tax rate and you can't stretch it out over the person's lifetime? You've got a 10-year term to work with. Is it worth it? That's a question to talk to Bridget about. And now with that, for something completely different.
And the good news is that this is also along the lines of simplifying some rules that apply to safe harbor plans. One of the first simplifications that came for safe harbor designs was the increase in the safe harbor rate cap for qualified automatic contribution arrangements, or in layman's terms, QACAs. Previously, plans that had a QACA arrangement were limited to a contribution rate that was capped at a 10% automatic contribution, or 10% of an auto escalation with respect to an employee's automatic contributions. Now, the Secure Act has actually increased the QACA rate cap for plans starting after December 31st, 2019. Now, the 10% cap is retained for the participant's first year of participation, but then allows it to be increased to 15% thereafter. Again, this is optional, it is not required, but it does appear to address the industry's concerns that the 10% cap was too low in relationship to the goal of helping employees increase their retirement savings for the future, especially those employees that aren't making their own elective deferral elections. One item to note, plan sponsors who do have a QACA safe harbor design should consult their own plan documents. Sometimes plan documents may make a cross-reference to code section 401K13 and not necessarily include the specific percentage of contributions. In those cases, plan sponsors will want to coordinate with vendors and counsel to determine what rate is actually in effect for 2020 and determine whether or not there are any administrative changes or plan amendments that should be made.
And just for those who are viewing via webinar, I'll note that we're moving on to slide 9 now.
And on slide 9 comes another welcome simplification for safe harbor plan sponsors, and this has to do with notice requirements. Previously, regardless of the design of the safe harbor plan, plan sponsors were required to provide employees with an annual notice explaining several features about safe harbor plans, including the safe harbor contribution formulas, elective deferral rates, vesting, and so on. With the changes from the Secure Act for plan years beginning after December 31st, 2019, safe harbor plans that only have an ADP safe harbor, so you're only really making non-elective contributions to the plan for employees, plan sponsors do not have to provide the annual notice. However, please note, if there is an ACP safe harbor design and there are matching contributions as part of this, employers are still going to have to make this notice on an annual basis. And to a certain extent, this makes a bit of sense. Employees who have to make a certain percentage of elective deferrals each year in order to be able to obtain this safe harbor contribution should have some form of notice. They need to be aware of what they need to do in order to receive the maximum employer contribution, whereas employees who are going to receive a qualified non-elective contribution regardless of their elective contributions may have less need of this. And finally, advancing to slide 10. The Secure Act also facilitates the adoption of a non-elective safe harbor plan design. Previously, when an employer is amending a plan to adopt a safe harbor, these amendments typically had to be adopted prior to the beginning of a plan year in order to have the safe harbor apply. It was possible, however, to adopt it within the plan year at a 3% contribution rate, provided that certain conditions were met. Following the adoption of the Secure Act, it's possible for plan sponsors to adopt a non-elective safe harbor design at a 3% contribution rate during the plan year, provided it's adopted no later than 30 years prior to the end of the plan year, which is a very welcome change because it allows an employer to make a decision mid-year, we are going to put a non-elective safe harbor in place. Furthermore, it's possible to adopt this safe harbor design at a 4% contribution rate at any point in time through the end of the following plan year, provided that the non-elective contribution that's being made is at 4% for both the prior year and the current year. So for example, a plan could adopt a non-elective safe harbor for 2020, sign the amendment in 21. However, the contribution rate needs to be at 4% in both 2020 and 2021.
And so now I think we're on to slide 11. And Tim, do you want to talk about the lifetime income provisions?
Yep. So we've got lifetime income provisions put in play by the Secure Act. And, lifetime income is not really a new concept for pension plans. We've got annuities and defined benefit plans. I'm sure there's several 401k plans out there that still have annuities as an option, although many have been amended away over the past 10, 15 years. But one of the things that the Department of Labor did about 10 years ago was to ask other agencies for input on how lifetime income types of distributions could be more readily available and I guess more practical from a plan sponsor perspective in an individual account type plan like a 401k plan. And so the Secure Act actually comes along 10 years later and helped remove some of the barriers, provide some more disclosure, a safe harbor for fiduciaries, and make some of the transfer from one vendor or plan to another a little easier. That was one of the impediments as well. So the first thing we're gonna hit is the disclosure issue. What the Act does is it requires individual account plans, such as a 401k plan, to include a lifetime income disclosure at least once during a 12-month period. The disclosure has to have certain things in it, but it also is going to be required to be made 12 months after the later of the DOL's issuance of the later of the following, the interim final rules, model lifetime income disclosure that they're going to put out, and the assumptions that obviously have to go into doing a disclosure like this, either to convert the accrued benefit into a lifetime income stream. The DOL is required under the Act to issue all this guidance by December 20th, 2020, which is 1 year following the enactment. There's also liability relief under Title I of ERISA if the disclosures comply with the interim rules, model disclosure, and assumptions. So from a fiduciary perspective as to the notice, if the notice contains all the things that the DOL guidance prescribes, there's fiduciary relief on the notice itself. Content requirements are going to include the benefit expressed or total accrued benefits as an income stream, which would include a life annuity and a joint survivor annuity, assuming the spouse is the same age as the participant.
And Tim, I might just add here, if you don't mind, I think this is going to lead to a fair amount of confusion. I think others here on the panel might think the same. I mean, one of the difficult things is that, in essence, there's going to be these assumptions, and I'm sure we'll have some amazing new page-long disclosure to participants saying you could take your $100,000 401k account and convert it into a lifetime annuity of X or a joint survivor annuity of Y. But if the plan doesn't offer annuities, first of all, that means they'd have to go out to the market to buy annuities, and participants are likely to find that means they'd actually be able to purchase less. Because obviously selling and buying an individual annuity is not the same as getting it through a plan. I think that it's also going to be difficult, given that they're anticipating that spouses are the same age, that's going to be misleading. At the end of the day, it may be like many communications that plan sponsors provide these days that participants just don't read or look at, but I think that it's going to be one where in some ways, this is actually, in some senses, I can see it as being helpful for people to think about how long is my 401k account going to last. But on the other hand, I think it's going to impose some burdens on plan sponsors too, Tim.
Yeah.
Yep, I'm sorry, but I'll switch to 12 for you.
Question?
So for plan sponsors that are currently fulfilling statement requirements through a readily available website or electronic statements, do you see anything different happening sort of in the first issuance or application of this guidance?
I haven't seen anything on that. I don't, one would hope that that sort of dissemination would still work on these, but I think it's kind of
Yeah,
We'll see.
with no guidance yet, I would anticipate that like the annual notice on fees and rates of returns, maybe this will be added on or tacked onto that, or the DOL will say that. We obviously don't have that guidance yet, but it might just make it a longer notice of some type. Yeah. Okay.
Okay, the next component on the lifetime income was fiduciary relief. So one of the concerns of plan sponsors was, well, if we go out and have to buy annuities for these people that want a lifetime income stream, and we select an insurance company that maybe seemed okay at the time, but then later has financial difficulties, are we somehow fiduciary liable for that decision, and have we followed prudent practices of doing that? And what the Act does is it creates a new optional safe harbor under ERISA Section 404E. And what it does is it defines the prudent selection of a guaranteed retirement income contract, or now we have a new acronym, GRIC. And essentially, from the definition you can see there, it's an annuity. In order to get the fiduciary relief, the insurer has to provide the fiduciary with a variety of representations, primarily concerning the solvency of the insurance company, that they're being regulated by the state, they've got the adequate reserves, and so forth. I think it's going to be fairly straightforward, but the insurer has to notify the fiduciary also of any change in the representations that were precluded from making representations at the time of the contract issuance. There's a couple of timing things here. One is the time of selection of the provider, and then there's also a periodic review that's required to be done. The time of selection of providers is the distribution of benefits or the time to provide benefits at future dates. And so that's the time when you have to kind of evaluate the selection. Again, it requires periodic review of the continuing appropriateness of a fiduciary's conclusions in terms of selecting that particular provider of the annuity. And the annual representation of the insurer is deemed, that we talked about in the prior slide, is deemed to satisfy the periodic review requirement unless the notice of change is provided or the fiduciary becomes aware of other facts that would cause it to question the insurer's representation. One other thing that the Act does is it specifically talks about you don't have to select the lowest cost annuity. Other factors can come into play, so that's a relief as well. Finally, on the lifetime income portability, or lifetime income issue, is portability, and one of the barriers in some of these plans was if you offered annuities and you had a provider that was your contracts within the plans were annuities, it might be difficult to switch vendors without surrendering the contract. The Act adds Code Section 401A38 to help facilitate the transfer of these types of products between record keepers and vendors so that those lifetime income opportunities aren't lost.
Continuing on with defined contribution plans, I am now going to talk about what I'll call the hodgepodge of changes and just little things that have been done here. So the first one is about no credit card loans. You may say, I hadn't realized I could get credit card loans through my 401k plan, but theoretically, if your 401k plan allowed them, you could do what was called a credit card loan. Basically, the Internal Revenue Code hadn't limited the number of loans, and the DOL had issued some guidance indicating that hey, as long as you meet all the requirements of the code, we're fine. If you wanted to go ahead and put a loan onto a credit card or have a credit card be a revolving loan or whatever, that's fine. Congress for several years has thought this is a very bad idea. It should be much harder to get loans out of 401k plans and other plans that are allowing loans. And so they have prohibited loans through credit cards or similar arrangements. And that was effective as of the date of the enactment of the Secure Act. I'm fortunate that I don't know that I work with any entities that have used this provision, but that is out there. And if someone has a plan that allowed that, they should talk to someone immediately about making sure that that's not currently occurring because they're prohibited. One expansion of the distribution options is that the Secure Act added a provision that allows distributions when an employee has or a participant in the plan has a child or adopts a child to allow a distribution to help with those expenses. Basically, the Secure Act is going to allow a distribution of up to $5,000 within 1 year of childbirth or adoption. In subject to certain limitations here, of course, if it's not the adoption of a spouse's child or limited to children under 18 or with certain disabilities. But that is a nice basis to go ahead and allow some additional basis to get money at that time in a person's life. There is a requirement that if a plan sponsor adopts this, they also then have to adopt a provision that will allow repayment of that amount. And as with everything that we're talking about up here, so far the IRS really hasn't issued any guidance. Of course, it's only been a few months. But I think the guidance and the details will really be important for plan sponsors who are considering this. I don't know how popular this is going to be, but I have a suspicion that many employers who do work to have very family-friendly workplaces will be interested in adopting this and then trying to figure out how they would allow for the repayment and addressing other issues as the IRS comes out with guidance. This is something that is available now. If a plan sponsor was so inclined, they could talk to their provider and see if they could be amending their plan to try and allow this to be occurring currently. Another small change, and this is probably not going to affect a great number of employers, but just to note, there was a change in the definition of 415 compensation. 415 is basically what is considered compensation for purposes under the plan. And generally speaking, items that are not taxable income are not compensation under a plan. However, the Secure Act has modified the definition of 415 to provide that if an employer is providing payments for, due to difficulty of care, payments for foster carers, helping employees with that kind of arrangement, that then those amounts can also be considered compensation for purposes of 415. This is retroactive back to years after 2015. If anything, I would think that this would actually just help an employer in terms of protecting the employer from any past practices, but I don't know that that will have a significant impact, but that is a change in the definition of 415. One of the more unique, I'll call them hodgepodge changes, is the expansion of 401k plans to more individuals, in this case, part-time employees. So there's been I think it's fair to say that there's been a great deal of interest in the fact that many individuals still are not covered by a retirement plan in this country. You have seen over the past 5-7 years, different states enacting state legislation. Illinois and California and Washington State are three of the states I think are farthest along in this, basically mandating that if an employer does not offer an employer-sponsored retirement plan like a 401k plan, that they enroll their employees in a state-sponsored type of retirement plan, similar oftentimes to like an IRA, but there's different designs. And in part that's because states are concerned, well, these people are going to hit 65 and they won't have sufficient retirement savings, and what does that mean for our state and the need to provide services to these individuals? I think there's been some concern in Congress as well, and so Congress has gone ahead and expanded eligibility for part-time employees. Now, this is a prospective provision, as you'll see, but basically it's mandating that the part-time employees we'll be discussing are eligible to participate to make their own elective contributions. It does not mandate that they receive employer contributions, but just that if you have a 401k plan and you're offering it and you have part-time people who meet the criteria, you have to allow them to make their own elective contributions. So previously, defined contribution plans other than 403B plans generally did not have to cover part-time individuals. You had to just cover someone who had completed a year of eligibility service, unless they were in some sort of non-discriminatory classification that you excluded altogether. Under the Secure Act, there's now this dual eligibility you could view it as. One is if a person meets the 1 year of service requirement, generally again that they've worked for 1,000 hours in a 12-month period, or that there are 3 consecutive years in which the employee works at least 500 hours of service. So that's a new thing where you'll be measuring service over periods of time, and if they meet that 3 years, then they can get in to make their own elective contributions. As the slide notes, you're not required to make matching or non-elective contributions to these employees, and you're not required to treat employees who are eligible solely based on the new provision, but you do need to treat the people who are based on this new provision for vesting. If you were to make those kind of contributions for matching or non-elective, you'd also have to treat a year of service where someone had 500 hours as a year of vesting service for those folks. The new requirement, by the way, does not apply to collectively bargained plans.
Tim, if I could just make a comment.
Please.
in addition to not having to make matching or non-elective contributions with respect to these folks, so they're also excluded, I believe, from non-discrimination
Yes,
testing rules.
that is
So I think,
correct.
yeah.
Yeah, so they wouldn't have to be counted if you're not making those contributions, is the point Mike is making, which is a very important point.
Or even though they are sort of forcibly eligible to make deferrals, I believe they're still, like, if they choose not to make deferrals, they
They're
don't
not
count against
tested.
you, yeah.
Exactly.
Yeah.
The good news is that service before January 1 of next year does not need to be counted for this, which is going to give employers a chance to look at their workforce and their plan design and think about what they should be doing with respect to this new requirement. Obviously, I think there are some industries that are going to be more heavily impacted than others. I think retail is going to be a place that you might have a greater impact. I think agricultural businesses where you may have seasonal employees in particular is going to be having more heavily impacted. And so other entities like that, especially where you have seasonal employees or ups and downs in the workforce, this is something to be looking at. There is some time, and again, the IRS has not yet issued guidance on this. So technically, if you were to adopt this provision, it's not until actually 2024 that you would need to allow these people in, because they would not have completed the 3 years of 500 hours until they get into 2024. So there's a little time to look at this, but this is something people will have to consider. I should have said we're on slide 21, and we're actually now moving on to slide 22, and we're going to be talking about multiple employer plans, and I'm going to turn it over to Mike.
Thanks, Tim. So, if many of you are affiliated or working in some way with a medium to large size plan sponsor, this may not affect you, but I do think nonetheless it is very interesting. The purpose around these changes is, in my view, long overdue. It's been for some time. Industries and other groups have been looking for ways to help small employers aggregate and take advantage of economies of scale and be able to achieve the same costs in terms of sponsoring, maintaining, administering retirement plans and offering investments under those plans at affordable cost. This legislation is designed to enable them to do that, and here's how. So prior to the Secure Act, in order for unrelated employers to be able to pool together and join and participate in the same plan, there had to be some sort of nexus between them. If there wasn't any sort of common ownership between the companies, there had to have been some sort of industry-related or geographical-related nexus in order to create some sort of commonality. And for some time, different interested groups, including eventually the Trump administration, started to explore, well, how could we re-examine that and find ways to broaden the use of what are called multiple employer plans to allow these unrelated companies to come in. And so even before the Secure Act, in 2018, the Department of Labor issued regulations that was directly in response to an executive order that were designed to allow for the expanded use of multiple employer plans, but still the regulation could only go so far because the statute in some way required there be some element of commonality. And so you didn't really get to a point where a professional financial services firm could just come in and announce, we're sponsoring a plan. All of you hundreds of employers out there are welcome to join in and participate in it. That just wasn't possible. At the same time, there also had been this historical rule dictated by the IRS and the Treasury that if you're going to have a multiple employer plan, then the rule is the one bad apple spoils the bunch. So if you have one employer that is somehow does something and risks a disqualification, it doesn't just affect that employer, it affects, in theory, everybody. And of course, that was a big deal. And so in 2019, the IRS, again, I think in response to an executive order, the IRS issued some guidance that, well, number one, it affirmed that the bad apple rule, or I think they call it the unified plan rule, still exists. It's still on the books, which wasn't helpful. But then they went on to propose ways in which one might mitigate the effects of the one bad apple rule, which is, in essence, giving plan sponsors the ability to take steps where they've identified a qualification error within sort of one participating employer, giving them an opportunity to either fix it before it pollutes the whole plan, or giving them an opportunity to withdraw out of the plan and go on their own and fix it on their own, or finally, the ability to sort of forcibly remove them from the plan. So that was all kind of laid out in Iras guidance. So with that, then suddenly we have the Secure Act. And the Secure Act actually goes way beyond any of that guidance and creates something entirely new that is actually under the statute called a pooled employer plan. And unlike the traditional multi-employer plans that we've just been talking about, this kind of plan can be, doesn't have to be sponsored by a trade association or some element where there's commonality amongst the employers. It can be truly open, which means that a financial services firm, which could be a bank, a trust company, or some sort of third-party administrator, can effectively construct the plan, and employers then can join as participating employers, and they don't have to have anything in common. And so I think it's probably readily apparent this is all designed to allow for these smaller employers to participate in a plan that gives them comparable administrative costs, and in particular comparable investment costs, achieving economies of scale that many of us are able to take advantage of working for larger employers. These PEPs are not quite effective. They're going to be effective, we hope, beginning in 2021. Not surprisingly, there's probably going to have to be quite a bit of guidance that has to come out, but in the meantime, this is what we know. The PEP has to be organized as a 401A plan that's a straight qualified plan, so that could be a 401K plan, for example, or a profit sharing, or a straight up profit sharing plan. Or, and this is curious because I don't exactly know what this means, or a plan of individual retirement accounts. So it could be something akin to like what we would call a SEP, like a simplified employee pension, where it's really an employer-sponsored arrangement, but underneath it are really just a whole bunch of individual IRAs. So obviously have to wait for further guidance as to how that's going to work, but it's conceivable that you could construct one of these PEPs not as a qualified trust, but as hundreds of, or thousands, apparently thousands of IRAs underneath the plan. There are some plan documentary requirements, and those stipulate that the pooled plan provider, so let's just assume it's a bank or trust company, that provider is the named fiduciary. So again, if you work in the normal single employer plan world, you know that the single plan sponsor is required to have a named fiduciary. Usually it is the sponsor or some organ within the sponsor, like a committee of some kind. Well, now we have this sort of professional financial services firm that is, in essence, the named fiduciary, and is really going to be largely tasked with maintaining the administration of the plan. Employers can be responsible for monitoring the underlying investments of the plan, but there's also a way where it's conceivable that I guess we call it the PPP, the pooled plan provider, we'll just say the bank, trust, financial services firm, that they could, under their construct, simply say, well, we'll designate there to be maybe an outside party, maybe it's an outside professional investment manager. In the industry, we call that a 338. That 338 would be responsible for managing the different investments. That's also possible too, so that you take away the investment fiduciary responsibility from the individual employers. Obviously, if they want that, there's probably going to be a plan design that'll allow that. But again, many small employers tend not to be very sophisticated and tend not to be very comfortable with picking and choosing and maintaining investment platforms on their own. So this would essentially allow for a provider to sort of come with a ready-made product to say that you can participate in this plan, and here's the investment platform, and we have somebody else that's going to monitor this investment platform for you and sort of swap out funds where there are underperforming funds and things of that nature. So
with that, yeah.
no, wait, I'm sorry, Tim, I actually had a few more comments.
Oh, okay.
I also wanted to just mention, I alluded to before, the bad apple rule, one bad apple spoils the bunch. The statute, the Secure Act, actually, on its face, it ostensibly repeals that rule as applied to PEPs. So that's good. But if you read more deeper into it, it looks as though there's also a framework that's being developed that would allow for employers, if they run into problems that create qualification errors, to be able to, again, to either voluntarily withdraw out of the program or for them to be kicked out of the program, which really tracks the proposal that the IRS issued last year. So it's interesting, because technically the bad apple rule doesn't apply to these PEPs, but at the same time, there's procedures in place that plan fiduciaries and sponsors need to follow in order to make sure that if there is a problem, that it's properly being addressed, and if necessary, forcibly removing bad actors.
Tim, you want to talk about DB testing?
Okay. So one of the things that the Secure Act did was address some testing issues that particularly frozen defined benefit plans have been incurring over the last several years, especially as more and more employers have frozen these types of plans. Previously, the IRS had come out with some rolling guidance every year to try to help provide some relief in this area, and the Secure Act essentially codified some of that relief, or made it so the IRS wouldn't have to keep coming out with a new set of guidance on it. What it does is it does three things. It allows plan sponsors to aggregate a frozen defined benefit plan with other defined contribution plans for testing purposes, if that's going to help the employer pass non-discrimination testing, and eliminates what's known as a gateway test, which it's too complicated to go in this particular presentation, but it basically allows you to get through a gate to allow these two plans to be tested together. And also allows matching contributions and other employer ESOP and 403B contributions to be taken into account with respect to testing, just to satisfy the non-discrimination test. So that was a big chunk of the relief. The other piece relates to what are known as benefits, rights, and features of the plan. And frozen defined benefit plans now, under the Act, get an automatic pass for those for testing related to benefits, rights, and features. One problem that some of these frozen plans would run into as well is they would hit up against Section 401A26 that had a minimum participation requirement. And that requirement was 50 employees or 40% of all employees covered. So when you had a plan that was closed, as people terminated the employer and there weren't any new people coming in, plans would get smaller and smaller, and then before you know it, they run up against this limitation. That limitation has also been eliminated for these closed plans. The question then becomes, what is a closed plan eligible for this relief? The Act provides that there are plans that are closed before April 5th of 2017 or satisfy what they call a 5-year rule. And the 5-year rule is stated in the slide. The plan existed for at least 5 years before the closure without a, quote, substantial increase in coverage or value of benefits, rights, and features during that 5-year period. It must have also passed testing for the first 3 years without Secure Act relief. And subsequent plan amendments can't discriminate significantly in favor of highly compensated employees. So kind of a very narrow set of circumstances for defined benefit plan sponsors of frozen plans.
Mm-hmm. A little bit more on DB plans, and this one I'll go through quickly because if it's limited scope, but as everyone here who has a DB plan knows, the PBGC rates have been increasing at a very stiff pace, which has led a lot of employers to reconsider defined benefit plans, and they're noted on the slide here. The Secure Act provides that for a limited group of plans, those that are sponsored by cooperatives and small employer charities, also known as CSEC plans, that they are going to be able to reduce their PBGC premiums back to the pre-2006 rule of $19 per participant and a lower variable rate as well. And that's effective actually as of the 2019 period for those plans. There's fairly few of those plans, so it's not a huge change for most employers. In terms of DB plans and actually other plans, another change is that the Congress has gone ahead and added an age 59.5 in-service distribution option that can be put into those plans. This is optional, it's not required, but now if you have one of those plans, you want to add it, including a money purchase pension plan or a governmental 457B plan, then you can provide for this in-service distribution at age 59.5.
If I could just add.
Oh, please.
I mean, what may not be readily apparent here is the last three topics, the testing relief, as well as these other premium relief, and then finally the distributions is all designed to stem the tide of pension terminations, which is really what's happening. A lot of our plan sponsors are running into difficulty with testing, maintaining sort of a walled-off, closed plan to a group of people, and they're having all sorts of problems passing, especially benefits, rights, and features was actually a really big deal. And then so the relief is designed to allow them to at least keep them in place. Similarly, companies were getting frustrated with the amount of premiums they're having to pay the PBGC, and at some point you just say, we'll terminate it, and then we won't have to. And then finally, a lot of plans like to offer these lump sum windows to try to clear out people, and they can't really do it to active participants under existing rules, DB plans, that is, defined benefit pensions. This rule at least now allows you to open it up to age 59.5.
Exactly. No, that's a good point. And on all these things, as everything else, we really don't have much Iras guidance yet, but it'll be interesting to see how plan sponsors take this guidance and use it in the context of DB plans. One more thing for myself real quickly, and this is slide 30 on 403B plans. For sponsors of 403B plans, oftentimes healthcare entities or other 501c3 entities, there had been an ongoing question of how to terminate plans and take steps forward because of previous Iras guidance. The Secure Act basically mandates that the Iras provide some guidance on this, and it's retroactive all the way back 11 years to 2009 going forward, so that entities that had been trying to terminate these plans and taken steps that they thought were reasonable should be protected in terms of those terminations. With that, we're turning to the same piece of legislation, but it's not the Secure Act, it's Division N. So you see at the top of the slides, Division O or Division N. Holly, would you like to talk about Division N, the Health and Human Services portion of the Further Continuing Appropriations Act?
Well, I like to call Division N the now we have some good news on the health and welfare side division, or at least in three parts. Division N actually contains 3 tax repeals that are very welcome for the employer-sponsored and the health and welfare industry. The first, and most notably, the controversial Cadillac tax has been repealed. Under the Affordable Care Act, employer-sponsored health plans would have been subject to a 40% excise tax on coverage that exceeded a certain annual limitation. So this was originally to go into effect in 2018, was delayed several times to 2022. And according to a recent study, the Cadillac tax would have applied to 1 in 5 employer plans had it gone into effect in 2022. So unless it was significantly revisited. Well, with the amount of tax and the complexities, this has been a welcome repeal at this point. Briefly on slide 32, another tax that's been repealed is the health provider tax. And this previously imposed a fee on covered entities engaged in the business of providing health insurance. It had been repealed for calendar years after 2020. There was a moratorium in 2017, pause in 2019, but the IRS wanted to emphasize that for health insurance providers, this fee is in effect one last time for 2020. And the final and third tax repeal relates to the medical device tax. Now, the medical device tax was a 2.3% tax on medical devices sold or imported in the United States. And usually this was more in the business side of medical devices, not necessarily those that were actually sold to individuals. However, starting for sales after December 31st, 2019, the medical device tax is also off the books. However, just when you thought July was going to be kind of easy and smooth sailing this year, the P-Corps fee has been extended through plan years ending before October 1st, 2029. So since 2012, this fee has provided revenue to a nonprofit corporation that's really had goal of improving care and reducing medical costs. The HHS Extenders has extended this for another several years, which means that self-insured plan sponsors and insurers will need to file the Form 720 and make the P-Corps fee payment by July 31st of 2020 for the 2019 plan year. Note, we don't have any guidance on what the fee is going to be this year per individual, but guidance should be forthcoming.
And so just a brief note there, there's, as with all these things, we in some ways would welcome some guidance on different things. But basically, for employers who are plan sponsors, this is a budget item perhaps. It might not be a big budget item, but you know, if your P-Corps payment last year was, say, $60,000, you should probably then say that you're going to have a P-Corps fee of $62,000 this year, something that you're going to end up paying for the plan year that's going to be due in July that you had otherwise thought was finally going to be dropping out of your budget. So for HR benefit groups, you may want to look at what the P-Corps fee was, and depending on your budget and allocation, follow up with your tax area and say, this is a fee that we're going to end up probably having to pay here as well. Subject to Iras guidance, and start budgeting for it yet again. And by the way, that was slide 34, and now we're going on to slide 35. After a renewed tax, it seems very natural to talk about penalty increases, and the Secure Act has several different penalty increases. I'm going to go through these a little bit quickly because we're getting close to our time here, but basically there are several different penalties that the Secure Act actually increased. So there's an increased filing penalty for filing late returns. And so instead of, say, $330, as is noted here, the penalty was adjusted to $435, and then or 100% of the amount of the tax due. And that is going to be effective for tax returns with filing dates after December 31 of 2019. Income, estate, and gift taxes, employment taxes, those are the types of taxes that are affected by that. The Form 5500, which is probably more relevant to this group, in particular, is something where the penalties are also going up. Now, this is a penalty, there's penalties available both under ERISA and under the Internal Revenue Code. This penalty increases with respect to the Internal Revenue Code provisions. Previously, it had been capped at $25 per day or $15,000. The Secure Act multiplied those by 10 and made those penalties effective for filings after December 31 of 2019. One of the things that'll be interesting to see, under current guidance, the IRS has said if you file under the DOL's delinquent filer program and you meet certain conditions, we won't seek to impose the penalties that we could under this section 6652E. The IRS hasn't updated that yet, but one would hope that that would still be the case given the much larger penalties that might be available here. And what happens is sometimes employers will, this is going to sound funny, discover they have a plan that they should have been filing on or failed to file on, especially in the health and welfare area. And so hopefully the IRS will provide this guidance. And if it does, then that shouldn't make a difference in a sense with respect to this. But this also points out that many employers may not have been aware that the IRS could also separately impose penalties with respect to late Form 5500 filings. Also, a few other things. There's annual registration statements and other penalties that are noted here. I'm not even going to run through them too much, but there are some filing requirements that, like a statement about deferred and separated deferred vested participants that's required. That's been increased by tenfold. Also, a penalty for failing to file an updated registration if your registration location is changing. That's being multiplied. And then finally, a penalty for failing to provide required withholding notices has been increased a fair amount. So those are some of the other changes that are baked into the Secure Act. A few final notes here, and then obviously we'd like to take a few questions, and we'll be staying around for people who would like to ask questions. But for church plans, there's some additional guidance here. I won't spend much time on it, but basically it's some relief to who can participate in church plans under a 403(b)(9) arrangement. If you're a church plan entity, you'll want to look at that. For governmental plans, many of the changes described in the Secure Act don't apply because governmental plans generally aren't subject to non-discrimination testing. So things like the QACA relief and other relief, generally governmental entities won't have those because they're not subject to that type of testing. There are other changes as well that are noted here on slide 40. There's some qualified disaster distribution relief over a period of time here for disasters that have not already been addressed by Congress. There is a retirement plan loan relief for victims of natural disaster areas as well. There's a filing extension that is being baked in now that if you're located in an area where there is a natural disaster, and let's say your 45500 is due, you get an automatic additional 60-day extension. So that's a helpful thing. And finally, there was a repeal of the UBTI tax that had been expanded for tax exempt organizations that provide qualified transportation benefits. So a little of something for everyone, you might say, here in the Secure Act. Those were some other changes made. I believe we're just about at time, and so if there's any questions, we'd be happy to take questions. Yes?
Changes in the Secure Act require us to restate the plan documents, or is it just like an automatic?
Sure. So the question was, and I'll just repeat this so everyone heard it, does the Secure Act require you to automatically restate your plan documents? And I think the answer is no. If you, I think you could look at it two ways. There will be an amendment deadline for some of the mandatory changes. Unless I'm mistaken, I think the amendment deadline is the end of 2021 or 2022 for non-governmental plans, as late as 2024 for governmental plans. In that period of time, many employers are on pre-approved or documents of one type, of volume submit or other pre-approved document. And I think with the next cycle of those documents the IRS will be approving, they'll include the Secure Act changes in those changes. It's also quite possible that providers and vendors, once they have some guidance from the IRS, are going to come out with, say, a Secure Act interim amendment that you can check boxes on and go from there. Hey, Mike or Tim or Holly?
Well, I was just going to say, the changes, many of the changes are not automatic. If you sort of look, for example, at the required beginning date distributions, first of all, plans, just by plan design, have different, they allow or don't allow different distribution features. So it's, your plan probably inevitably is going to have to be amended to make some changes, unless, for example, your plan only allows, say, lump sum distributions to everybody. Well, then there would be no need to make any changes related to the, the minimum distribution rules. But even then, there's rules affecting your required beginning date, going from age 7.5 to 72. Most plans usually recite the age 7.5 rule, so you would likely have to go in and do some cleanup there. Some of the other things, is sort of Tim was alluding to, are optional, and we don't have a lot of guidance yet on, but eventually when we get guidance on the distributions for childcare and adoption, which allow for repayment, which is a totally novel thing, we're likely going to have to do some plan amendment there around that, if you choose to offer that feature in the plan.
Any other questions? Well, thank you all very much for listening to us talk about the Secure Act. We appreciate your time. Thank you.